Recall Seth Harrison at the Lawrence County Jail. CRB 23322.
All right, we're back with Seth Harrison. Seth is on the video, and Lance Thompson is here, and Philip Heald. Lance, do you have something to tell us?
Yes, I spoke with Amanda Rayburn, who called me back within about 3 minutes, so I really appreciate the professionalism. She is sending Destin Holbrook over to assess Mr. Harrison tomorrow. He's already on their books. He's been a client. And if the assessment looks like the residential makes sense, then they'll take it tomorrow. So we'd ask for an OR bond subject to Seth being only released to the VA.
So what we would
And
request,
Amanda Rayburn, you know, is the court liaison there.
I can't hear you, Charlie.
our request would be that there be a $5,000 cash or surety bond, which can be modified to an OR bond, provided that the VA is going to take him. Otherwise, we'd want him to stay where he is until, and we'd like to come back on Friday to assess
I won't be
his
here on
current.
Friday, it'll have to be Monday.
Okay, a week from today.
Does it automatically become an OR bond?
If they take him,
Okay.
that's what we're requesting.
Well, I'm fine with that as long as it automatically becomes an OR bond if they take it.
I got a question. Can I ask a question?
Wait just a minute.
Lance. Lance. I don't think he can hear you. Yeah, there's speakers.
Okay,
He can hear you better.
you're represented by Lance Thompson. You want him to ask the question?
I didn't hear what he said, sir.
Seth, the VA is going to come over and talk to you tomorrow about possibly being in their residential program.
Come over and talk to you tomorrow?
Yes,
To him, no.
to you. The VA will be there tomorrow.
You mean go to the VA as an inpatient or go to the VA just as
It
an
depends on what they say.
And what if they say outpatient?
Then we'll come back next
I'm
Monday
locking
and
myself in a mental
discuss
hospital. There's nothing mentally wrong with me. I don't have a mental problem. I got a thief and a liar problem at my house.
They're going to be assessing you, Seth. They're not putting you in a mental hospital. They're not locking you up in a mental hospital.
That's fine. I'll go over to the assessment, no problem, sir.
All right,
Well, they're going to come see you. And they're going to tell me what they're going to do tomorrow after they assess you.
I don't know what the VA is going to say, but if they say.
$5,000 cash or surety convert to OR if released
The doctor that he was seeing at the time.
to the VA.
Was calling him and said that Edmund would call him back.
And then
Like it was.
pre-trial, I guess, on Monday.
Pre-trial on June 5th, 2023 at 10 o'clock.
Is that Monday?
Yes.
Okay.
So how long do I have to stay there?
Well,
We're going to find that out tomorrow.
all right.
How's that fair? I haven't done anything.
Thanks, Seth. I'll be calling you.
Thank you.
Thank you.
Thank you, sir.
For Phillipston, Lawrence County Jail.
Okay. That's what you were asking for, right? 5,000 cash or surety convert to OR if released to the VA?
Yes.
Thank you. Thanks, Seth.
I guess I understand.
Jailer, we're finished for the day. Now, is this one over next?
State of Ohio versus recalls Adrian Waldron Bishop, case number CRB 23-174, A and B.
While you were in conference, Mr. Hill, a lot of things that going on with regard to Adrian Waldron Bishop. Chris Lovins is here from Recovery Resource Group, and he's in the process of trying to get her a recovery counselor. Is that right?
No, sir. A recovery coach. She's already
Sorry.
doing therapy with our
Yeah.
sir.
I couldn't read my own writing. And she's the one who will help get her to appointments, or is that going to be you?
Yes, either or.
All right? And they're also trying to get her into branches, which is a residential facility. Now, I'm recalling the warrant. Where do you work?
Pottery Place in Huntington on
Where?
Pullman Square.
Okay, all right. I know you've been through a lot, but you've got people helping you, you've got a lawyer helping you, you've got a gentleman who's trying to help you in more ways than one. So,
Yeah.
and one thing he's going to do is get you to your court hearings. It's always better to show up so you don't get warrants issued.
I understand.
All right, Mr. Moore. Now, I've set it up so Mr. Hield understands what's going on. Now, let's convert this to a pre-trial if we can, because we've got everybody here.
We have an offer to resolve the case. The treatment part of it would be the absolute imperative of any agreement. We want her to continue with that. But we also would be, if she were to agree to plead guilty to both charges, we would offer to recommend a 30-day jail sentence suspended and probation and complete her treatment as part of her probation. Otherwise, we do have to go forward with the case. We're encouraged by the fact that she's in recovery. We want her to continue doing it, but we still need to pursue the case also.
So we have aggravated menacing, 2 charges, and they're both Tory Sherrod, is that right?
Yes,
One's Crystal Sykes is the victim.
two different victims.
Like, how does that work?
Both at the same date and time.
Yes.
And just tell them I'm going to therapy, or is that all it is?
What you've been doing past week.
I have a question. I don't know that much about probation, but where I have to go to work and I'm dealing with like some other issues and where I'm at the mission right now, and I can get him for transportation or whatever, but I'm not sure how that works exactly. Like, what are they?
Well, you're lucky to have John Major here right now. Tell her, you heard the recommendation.
I wasn't listening, Your Honor.
All right, go ahead with the recommendation again.
30 days in jail suspended, complete her treatment, be on probation.
Okay. Standard probation is at level 4 reporting.
She wants to know what that would require of her.
Level 4 probation is an reporting probation that you report every other month. It's 1 day a month, and you just come in and see me.
Okay.
We do random drug screening, but other than that, it's as long as you're good in your treatment and you're making payments and stuff like that, your probation usually isn't
Making payments.
on your fines and costs.
What are my fines?
They haven't determined that yet. I don't know what that's going to be, but there is a cost to this. So there will be some sort of court cost and fine to this somewhere,
It'd be 110 in court cost.
at least. Yeah. Making payments on that, and you don't get any more trouble with any state or federal laws, you should be fine.
And it'll be for 3 months?
No, it's 2 years is what we do.
2 years?
It can be longer or shorter how this case goes on. If it takes you longer than 2 years to finish your treatment and everything like that, then it will extend on. But if you come back and the judge cancels your case early, then your probation can be early.
What exactly constitutes finishing my treatment? Because I've been in
I have
therapies for.
I have no idea. I can't answer that. That's up to the treatment facility.
Riverside, or see it have to answer that.
He may not even know the answer to that right now.
Yeah.
If I'm not mistaken, I think, I know for the fact it's either 8 months or 12 months. And she's been with us for a couple months now.
The probation that Mr. Hill is recommending is probably the easiest thing you're going to do. John just set it out every other month once, right? And how long do those meetings last?
5-10 minutes at the most.
So.
Where
he's-
is it located?
Right here.
He's just monitoring your progress to make sure you're doing everything. And you didn't ask for any fines or community service, did you?
Did not, Your Honor. And we would just take no position on those things. But, the primary thing is we have 2 people who were harmed by this. At least they were scared by what happened. And so the 30 days in jail suspended is to ensure that doesn't happen anymore, that kind of thing doesn't happen. And then we want her to continue with her treatment. And frankly, there are some times when it's a lifetime commitment to treatment that we would not, from the prosecutor's office perspective, expect her to be on probation forever. But we just want to make sure that she's advancing in that and using the resources that are available to her, and at some point she may decide, even if she isn't on probation anymore, that she's going to continue using those services because it helps her in her life. So, but for now, I think that she has progress that can be made in treatment that can be monitored.
I'm sorry, I have another question. I'm currently going to court in Cabell County to try to get custody of my son back. My ex-husband is a police officer and he has custody of my son right now. Is me being on probation going to, is it going to go on my record? I'm just wondering how it's going to affect my other issues.
The answer to that is, I don't know how it'll affect it, but it is going to be on your record. If you plead guilty, yes, it's on your record. After a certain amount of time, you can get that sealed, that record sealed, which means it's like it doesn't exist. But here's what you have. You've got 2 misdemeanor charges that Mr. Hill wants to pursue. In other words, he's not coming in here asking to dismiss these cases. So you've got 2, relatively serious charges, misdemeanors of the what degree? 1, misdemeanors of the first degree.
And if, we could be asking for her to go to jail.
Right. See, what he's saying is, the prosecutor is not asking for these cases to be dismissed. So you have 2 choices. You can accept the plea bargain arrangement, or you can go to trial and then see if you're found guilty of it. So.
Okay, so probation for 2 years, come in every other month.
That's the court's obligation. That's all they're asking for. And I'm not going to impose any fines for community service. What basically we're trying to do is get you through this counseling period.
Okay. Okay, that's fine.
Okay. I didn't hear the last sentence.
Do you think that's a good option, the best?
If you did what they had Mason did, yeah, that's a good deal. If you didn't do it, no, it's not a good deal. If he can shove it, that's a good deal.
Was there a request that she just be restrained from the victims on both these cases?
I'm sorry.
Was she to be restrained from the victim on both of these cases?
Yes,
2 victims. Both victims.
and we'll have to do no contact orders on those.
Okay. Yeah, I'll do that.
And is it Riverside Recovery that she's doing treatment with?
No, it's Recovery Resource Group.
Judge, I'd like to add a third option. We'd like to have a short continuance so she can consult with her West Virginia divorce lawyer, and I feel better if I sat down with her and had a discussion with her, because I feel like there's some questions in her mind that she doesn't have answered.
Okay, then I'm going to grant that continuance until Friday,
We're going to ask for a time waiver,
and and the state's asking for a time waiver.
So,
but you know, it's just as easy to set it for a trial. If she doesn't think she's guilty, I understand that, and she has the right to a trial. But if she just want to continue to talk about it some more, we don't oppose that either.
I might even have a chance to have a conference with my client.
Okay,
I'd
I'm
like to
granting
please
the motion
have that opportunity.
okay.
for continuance that Mr. Morford is asking for. And it's till June 2nd, 2023. That's this Friday. And bond continues. And please be here at this hearing, okay?
Yes, sir.
Since you've talked to her before.
Okay.
Thank you, Your Honor.
Thank you.
Thank you.
State of Ohio versus Catherine Stapleton, case number CRB 2372.
Hey, Butch.
Catherine Stapleton.
There's a cross-filing, Your Honor.
Look inside on the actual
There's a cross-filing.
Who's
Who's the cross-file?
Austin May.
Austin who?
May.
State of Ohio versus Austin May, case number CRB 23273. That's Mr. Holt's case.
Your Honor, Mr. May is in agreement with the state. I'm not sure with the other co-defendant's position, but Mr. May is wanting to request that this be put on a 90-day continuance and dismissed in 90 days. There's no further problems in paying the court costs.
That's our recommendation if they both want to do that.
Well, let's start off with saying that that voice you heard was J.T. Holt, who is the attorney for Austin May. And also that Catherine, by the way, Austin is here. Catherine Stapleton is here with her lawyer, Warren N. Morford, Jr. Now, for the record, Mr. Holt, on behalf of his client, has agreed to the proposition that the state has offered. And let's have it for the record, Mr. Heald.
Well, the offer is that if they, and I believe that they want to stay together, and if they want to do that, we need to have them be on their best behavior, not have any further problems for approximately 90 days. And then we would come back to court after that, and if there haven't been any further problems, then we would agree to dismiss the charges if there was one set of court costs paid. We'd also like to have them drug screened, just to make sure there's not drug issues.
Right, we determined date in which case the court costs will be put on, so there's no confusion in the clerk's office in collecting the costs.
We're fine with that, Your Honor.
See what wants to do it.
Yeah.
Is Family Medical Center here? Or did you just get this on the fax?
They just handed it.
That would be Mr. Morford?
Yes, Your Honor.
All right. Okay, Mr. Morford, did you hear the proposal that Mr. Hill had offered?
Yes, and my client is in agreement.
Okay. Now, Catherine, state your name, please.
Catherine Renee Stapleton.
All right. Are you married to Austin? Oh, okay, okay, say yes or no.
No.
And are you living with him?
Yes.
All right. And Mr. Heald is saying that you and Austin want to continue to live together, is that right?
Yes.
All right. Austin, state your name.
Austin, May.
Are you living with Catherine?
Yes.
Is that what you're wanting to do?
Yes.
Okay. Now, do you both understand the 90-day continuance?
Yes.
Yes, Your
All right.
Honor.
Your Honor, which defendant is going to pay costs?
Which defendant is going to pay costs? And how much is it?
It'd be 135, I believe.
135?
But the other defendant would still need to pay the $25 for the attorney fee to collect that's in the state.
So it's 135 plus 25?
Well, the 25 will have to be on both cases, but the 135 will be on the case that's been dismissed.
And we'd like to have the drug screens done before we
Catherine's
decide
on.
when the date's going to be.
I didn't hear what you said.
He wants the drug screen.
Okay. Catherine would agree to pay the 135 court fee.
All right.
Another thing I'd like to say also, Your Honor, is that both of these people are 19 years of age, so they're very young. They're living together, which, at this stage of their lives, it's probably a difficult thing because they're still figuring out who they are individually. We're not suggesting at this point that we would require this to be a part of the agreement to go forward, but they may think about getting a little bit of relationship counseling too if they intend to stay together, because they've got a long life together if they're going to stay together. And the allegations are not the most serious we've ever seen in the court, but still there were enough to get the police involved. So we'd like for them to think about that. If they want to stay together, they want to have a strong relationship.
They're both in agreement with that.
Your
Shaking
Honor,
their head, yes.
We want to do the drug screen, and we would ask that we set it for August 25th. Does that work?
Not me. That's fine. But
That's
we'd like-
good, right?
That's 90 days out.
All right. Pre-trial, what date?
Yeah. But we do want to have it recalled after the drug screens are done.
Okay. Pre-trial, August 25th, 2023 at 10 a.m., so long as we get a drug screen that everyone's happy with. And I'm going to need an entry signed by Mr. Morford also. Waiving time.
Just hand it to the prosecutor.
State of Ohio versus Brandon J. Adkins, case number CRB 23-138.
Okay, now, that is Catherine. Are you serious? James T. Hope, representing the defendant, is here. The defendant, Brandon Adkins, is here. State your name, Mr. Adkins.
Brandon Atkins.
Thank you. Mr. Holt, this is a pre-trial.
I guess we're just going to have to set it for trial, Your Honor.
How long will it take you to be ready for a trial?
I could do it June 16th.
Okay, what's our time situation on this?
Well, it's an M3, so it's 45 days. There was a discovery demand that would add some days.
We didn't have discovery, and we indicated we didn't have discovery, so I don't know how long it would actually just...
Let's take a minute and find out the exact time situation.
So what happened was the original discovery was sent to Mr. Holt and apparently went to his junk mail file or something and had to be found out or resent or something. Well, look, if you want to have it on June the 16th, just waive time till then. That's
Because we got a time argument now.
Wait. If we have a time problem, I need to know it. And if we don't have a time problem, Judge Capper sent me a note, he doesn't want to do anything before June 20th unless there's a time problem.
Well, there was a time waiver between April 24th and May the 8th. So that is over 2 weeks. The summons, case was filed on April the 19th. Summons was for 4/3.
March 7th. The case was filed on March 7th.
The one I'm looking at says April 19th.
I've got it right here.
Could you bring that up, please?
What's the case number on that?
That's CRB 23-138.
Summons was printed on March the 7th.
Oh, that's the amendment.
Okay.
Oh,
It was filed in the court on March the 7th. It was several ran out on April the 3rd.
Wait a minute.
they set the arraignment?
Oh, the one I'm looking at is amended.
Okay, I see that.
Did you see the amended complaint?
The original would be what matters.
It wasn't
Yeah.
until April the 19th.
Okay, here's what I have. The complaint that was handed me by Mr. Holt was dated March 7th, and, you know, I don't see what in here that says that. That's really strange to me.
Do we know when the original summons was? For what date?
The original summons was printed on March the 7th, and it was set for arraignment on April the 3rd.
All right, so that's when the time starts, right, JT?
It was served the summons.
So starting April 13th,
No, it was served the summons.
some reason, Dorothy,
We had an arraignment on April the 3rd. That's typically when they would be served with the summons.
We do the conference, so we got
So that's when you get served with the summons.
the day he was served would be, since he wasn't arrested, the day he was served with some.
Then that was April 3rd.
I might need a copy of that. For some reason, the original complaint is not in the file. Oh, wait a minute.
It's stapled to the amended one.
There it is. It is here, JT.
Okay.
No, wait, no, it isn't. No, it isn't. I'm looking at the amended one. I went to your... Here. You find it.
No, we don't need that. So from April the 24th to May 8th, there was a time waiver for that period. That's 14 days. There was discovery filed. What date was discovery filed?
I'm not sure.
Ron found the original.
Wasn't filed, but it was, maybe it was filed.
It was attached to the amended complaint.
April 19th, we answered on May 1st. So that's another, let's see, well, that all happened in the same time period. All right, so,
Because that's why was to get the picture as well. Why we agreed.
and to hold on to it because of this protection order hearing, which we did agree to do that. We actually asked for it to be set for trial on May 3rd, and then we were asked to move it to May 8th because there was a protection order hearing.
Which we
on this.
won.
And then from May 8th to today, so 21 and 30th, 20, 18. All right, so we'll need to try it on Friday.
You're asserting your speedy trial rights, correct?
I mean, we don't have to, I don't think we have to assert that. It's constitutional and statutory, but
Well, my question is, are you waiving it?
no.
All right. It's set for Friday, June 2nd, 2023, at 12 o'clock noon.
I don't even necessarily agree that it has to be Friday. We don't know the date. He's going off the day that was the arraignment. The time starts when he was served with the summons. So time's probably ran.
Well, that's why I'm asking, if it, has it run or not?
There'll be something in the court file, should be when Mr. Atkins was served.
Well, let's find that.
We have the original complaint. Well, they would have been summoned in, told to come to court on the date. Well, so it, if that's the case, it burnt almost the entire time between when it happened and when he was summoned in. So,
Because it was a non-serious injury.
It's probably because they don't know the rules for speedy trial. Let's set it for Friday, and you file a motion.
There'll be a return in there. I need the return to that. You'll file my motion.
Your Honor, I've been informed that the original summons was actually, service was actually on March the 9th. The amended service, we don't know when it was, because they didn't put a date on it. But March the 9th was the original service.
So the time has ran easily.
Yeah, but it's it didn't change why did we amend it? Oh, really? All right. Let's see. We amended the complaint because of we were inaccurate originally on the dates, so we amended the dates, and I think that amends the substance of the charge, which would start the case, extend the time.
This is crazy.
There was a summons on the amended complaint issued April the 19th, but I can't find that in the file, and I don't know when it was served. Typically, it's served in the courtroom, but oftentimes the bailiffs don't get that signed anymore, so we would have to go back and listen to the audio to see if it was served on that day.
Correction on the dates does not change. It doesn't mean a whole new time starts again. It's the same facts. It's the same general time period. Why we're doing this. Crazy. Oh my God, I mean, if you're here now, trial because they're pushing stuff.
You still have to file a motion.
If you want me to go through all that, yeah. Just cost him more money for something that's,
Well,
we've already won with a lower burden of proof. I don't know why we're doing this.
because it was a different allegation.
I can't afford anything else.
Could we have this recalled and I'll have a chance to speak with Mr. Holt about it? Please.
Motion granted. You might hold it here.
Or recall.
State of Ohio recalls Adrian Waldron Bishop, case number CRB 23-174 A and B.
Should we leave?
Judge, after her case and co-defendant Austin May's cases were called, Ms. Stapleton, the mother of my client, grabbed me and said she cannot be here on August 25th.
Wrong case.
That's a different case.
Wrong case.
Which one you talking about?
The one you gave me was...
Oh, I'm sorry, Adrian, Adrian Walden Bishop. I'm so sorry, Judge.
No problem.
Adrian Walden Bishop is who I'm talking about. Her mother grabbed me after we'd been in court and said she cannot come to court on August 25th because she begins classes that day.
That's not, we're still, okay.
So I'd like to move
You're
it
on,
up a week.
no, wait a minute. Is it Adrian?
No.
No,
Yeah,
okay,
he's still talking about the other case.
all right.
Adrian Waldron Bishop is set for June the 2nd.
I think you're talking about Stapleton.
Huh? That's what he told me to recall. Mr. Morphy told me to recall.
He's talking about Stapleton.
That lady out there. Stapleton.
Then I may be speaking about Ms. Stapleton, Your Honor. I apologize.
Okay, that's under here. That case is finished for today, right?
That's what I thought.
All right.
That's what he ended. Okay. So,
What is your name? Huh?
Catherine Stapleton.
Catherine Stapleton.
State of Ohio versus Kathleen Stapleton, case number CRB 23272. And State of Ohio versus Austin May, case number CRB 23273.
Now I'm on the right page, Judge, I think.
Can't wait for him.
Did you see this?
She has a good screen.
Both of them have a good screen.
Murder trial that was
She has not.
before, I definitely can't do it.
Austin's is perfect.
Can you give me a suggested date?
Well, we can ask that they don't have to appear. Is it okay that they don't have to appear if they pay court costs before?
There's still another issue, Mr. Holt, before you get to
Okay.
that because of drug screens.
Austin's is perfect.
Okay.
Now, we're waiting on Catherine's.
I haven't been able to use the restroom yet. That's why.
All right.
But you can't come to court on August 25th.
Yeah.
Your mother just told me that.
Yeah.
Right, because you start some kind of schooling.
Yes. Because I'm in another job. But this week to my whole class.
We're not opposed to it being moved to a date before August 25th.
Problem with that is Mr. Holt has a murder trial.
That week, I mean, the week before, do you want to do a 60-day continuum instead of 90? I mean,
I don't care. I mean, can it be early in August?
yeah. What is 4th?
What day?
4th, would that work?
I'm gonna ask council to come and get these entries.
We ought to. I mean, we had him do one. August 4th, we're not opposed to August 4th, Your Honor.
Mr. Marford, judge wants you to get these entries.
Yeah, and then have,
Judge wants you to come up and get these entries.
Yes.
have Mr. Hill initial it.
Sorry.
No problem. He's going to change that to August 4th and have Mr. Hill initial it. And you go ahead and initial it too. Thank you. Okay, make it August 4th. These entries don't go into effect until you produce your screen. Has anybody provided you with water to drink? Good.
That's what I'm doing right now.
Excuse me?
That's what I'm doing right now. Before I came in here, I was drinking water.
Great. We'll recall them.
Thank you, Your Honor.
Is Mr. May free, we're good with, Mr. May's, we're good to go, right?
Mr. Hill?
He's fine.
Yeah, okay.
It's a perfect screen. Okay, I'm signing this one and filing it on Austin May.
State of Ohio versus Brandon J. Atkins, case number CRB 23138.
I still haven't had a chance to talk to Mr. Holt.
Oh, okay.
Haven't had a chance yet? Okay.
We'll call it again.
I don't know
I
how.
don't understand that.
I don't either. I've just been sitting here malingering.
State of Ohio versus Elizabeth Hoffman Howard. Your Honor, She was to report to jail today, by 11 a.m., and it's my understanding that she has reported.
All right, thank you.
She did report, Your Honor.
Thank you.
State of Ohio versus James O. Smith. Case number CRB 21749, TRC 212579, A, B, C, and D.
Is that Joseph or James?
This is what, excuse me, it is Joseph O. Smith. Thank you.
Warden Morford is here. And
Yes, sir. Yes, sir.
who's here from Riverside?
Bobby Glenn.
State your name again.
Bobby Glenn.
I think it's done today. Okay. It should be done. Yeah, I got my certificate, but I needed to ride the course, so they were making sure. Okay. Congratulations.
Yes.
Yeah.
He's completed with satisfactory progress.
Yeah, they were just making sure they didn't want to take me off, and I couldn't get around, the course, so they just, but I got my certificate. Wednesday, Thursday, last week.
I couldn't remember.
We're going to need Mr. Hill for this.
We're going to need Mr. Hill in the courtroom for this case.
It's a review hearing.
The judge just said we needed Mr. Hill tonight.
This is the sentencing.
It's a sentencing.
All right. I want to,
Mr. Smith has paid court costs.
Everybody.
Yeah.
Mr. Hill, this is Joseph Smith, and we have a report from Riverside, and what is this case? It's, how is Mr. Smith doing on his program?
He's doing great. He's actually completed.
So you're happy to discharge him from that program?
Yes, sir.
You're convinced that his dealing with his alcohol and
Yes.
cannabis problems,
Yes.
okay, even though he tested positive earlier in May?
Yes. His levels have decreased in his send-off screens, and he's no longer testing positive for alcohol.
Mr. Morford?
I'm not going to displace my opinion with the opinions expert. He's done his counseling, has agreed.
I'd like, Wes, would you get John in here, please? I assume then, Mr. Morford, you're asking that he be discharged from probation altogether.
Your Honor, he's not been sentenced on this case. It was a 60-day continuance with anger management counseling, relationship counseling, and family medical with costs dismissed, with court costs paid.
Which one is that?
CRB 21749. Then the 21 and 2579 that he has been sentenced on in 2021. For whatever reason, the domestic violence, he was never sentenced on. Didn't continue.
Okay, let's do it this way.
I don't know when that 60-day was on, but ultimately that was.
You know what, I don't see any of that in here. I don't see an entry that reflects that.
Because there's not an entry, Your Honor, because he's not been sentenced. That was, at some point, that was the recommendation. It could have been back in 2021, but he has paid court costs and he's never been sentenced, so he needs to be sentenced on this. The other one was a review hearing.
Okay,
He paid the court costs on April 21st, 2023. He was arrested on warrant way back in 2021. Somehow this one got overlooked, which isn't unusual, I guess.
He did his anger management with
Community
service.
service, I did everything.
what Dorothy's saying,
I'm looking at the computer screen where that was a recommendation made at some point, where it says dispo. The court types the recommendation. Whenever the person's sentenced, that recommendation is cleared off and the actual sentencing entry is put up there. So that's what I'm reading. You can refer to. And I just pointed out that he has paid his court costs in April of this year. He paid his court costs.
everything she's saying is correct. I don't see an entry disposing of the case. But I do see that he completed anger management in 2022, and I don't see any court costs or.
Well, Your Honor, it looks like he's done everything that we asked of him.
That's the way it looks to me.
So he's satisfied us. He's paid his court costs, he's done his counseling, and we don't have any report of any further problems.
All right.
So,
Can you put that entry back up? Oh, you just wiped them all out?
I can show it again, but yes, there it is.
Okay. Case dismissed. Now, let's go to John's case. He's under probation on the OBI, and he owes no community service and no court costs. So this is a 2021 case.
Prosecutor seems to think that he's good with them, he's good with me. I suggest that we close his case.
He's terminated from probation, Mr. Morford. So
Thank you, Your Honor.
that takes care of both cases.
Super.
All right?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. That is Joseph Smith. Now you called for James McClaskey, didn't you? And he's failed to appear.
State of Ohio versus, James McClaskey, is he the one that failed to appear?
Yeah, you need to call him. I don't think he's here.
I
don't see him.
We already called him.
Call him again.
No, he's on the sentencing docket. If you called him, I've been nice to know.
I don't have it.
Oh, well, just call it again.
I called it and he wasn't here.
Oh, okay.
So a warrant was issued.
All right. Okay.
He was.
Is that it? A warrant was issued on it.
All right, thanks.
All right? Thank you. Now we have Cooper.
State of Ohio versus Keith W. Cooper, case number CRB 21-288 and TRC 21-121 A and B.
Now, Mr. Cooper, state your name, please. You're under probation for an OVI and a littering case, and you owe $54 hours community service, $9.90 in costs. And your lawyer, Mr. Warren Morford, is here representing you. What do you have to tell me, Josh?
Your Honor, he was ordered to be here on April 29th and May 6th for his community service. And he did not show up those 2 days.
Okay, why not?
I don't have my license, sir, so I have a hard time getting around. So the only way I have around right now is my feet right now. I just didn't have a license, sir, that's the truth. I do have payment today, $50.
Your Honor, I would be all right with them paying $50 a day and coming to community service on Thursday.
Are you working now?
Somewhat, yes, sir.
Tell me about that.
I work for a company called BC Flooring, and they go and get remodels for carpets and stuff like that. And I'm just waiting on them to give me a call to get back out of town. Then that's all. That's the job I have right now.
Mr. Morford?
I think you can tell he's working right now, that he's trying to make some kind of effort, and if he gives his word to be here Thursday, then we should give him a chance.
What is your name, sir?
Robert Sturt, I'm his stepfather. I'll make sure he gets here.
Sounds, you just got a ride. Remember the ride you couldn't get? What is your name, sir?
Robert Sturt.
How do you spell your last name?
S-T-E-W-A-R-T.
All right.
Mr. Stewart, he needs to be here at 7:30 Thursday on the west side of the building.
And are you able to get him here on other days also?
Yes.
All right, sounds good. I'm going to accept a recommendation that Mr. Morford and Mr. Cooper have set forth, and we've got Mr. Stewart there. Your stepfather is here, willing to get you here, and you have orders for one day, but you need to get this taken care of. How do your hands get that dirty?
Working on vehicles, sir.
All right. That, Mr. Morford was using that as an argument to show that you are working.
Is he also making
I've got it covered.
a payment today?
Yes, sir, $50.
Which, by the way, I agree, you're working, doing something. And, okay, $50 payment, one court-ordered community service, June 1, at 7:30 a.m. And look, let's get this done. I gave you the numbers. When you're not working for someone, get in here and work with Josh. People love working with Josh. He's a good guy. And basically, it's not that you're not out there killing them, are you?
No, Your Honor.
All right.
Your Honor, what's the next sentencing? He's on the sentencing docket.
Oh, yeah, did I say, what did I call it?
I don't know if you said it in the hearing yet. It's
July 3rd, 2023 at 10 o'clock for sentencing.
July 3rd.
July 3rd, 2023 at 10 o'clock for sentencing. And I'd like to thank Mr. Stewart for stepping up and keep helping him. We appreciate that.
Thank you, Your Honor.
Thank you.
State of Ohio versus James Helton, case number CRB 23111. Might as well stay up there.
I haven't heard the name, I knew that from the room.
Okay. Now this one is, do you have a test for me?
I thought Mr. Mayor brought it in for me.
It's not good.
This is the same thing he did before.
Okay, Mr. Morford, you're representing James, and I'm gonna read a note that was given to me on the judge's desk this morning. And really, we need Mr. Heald for this also, so I don't have to read it twice. Okay, Mr. Heald, Judge Capper, on this case of James Helton, Judge Capper is involved in this case, and here's the note that he left me. Mr. Helton should go to inpatient treatment with an ankle monitor. He's under a bond with Gary Sallards. And he also wanted a test, which he came up with the same results as he had before. So, this is a pretrial.
It's actually a sentencing.
Oh, it's a plea of guilty?
Yeah,
Is that right?
I
We've
got
already
May
had plea of
20.
guilty?
Yes.
All right, it's sentencing. Thank you, Mr. Hill, for correcting me. Now, that's what Judge Capper wants.
Oh, okay. So yes, Mr. Helton was here, entered a plea, and then left right after that. I guess he was going to be drug screened and he didn't stay around, so that's what happened there.
I did drug screen, my drug screen told me he was Riverside, and I did, and they set me up for an assessment, and I didn't know I had to come back in here, and they told me.
Okay.
Well, the good news is you're here.
Actually, Judge, what happened was that before Judge Capper would accept Mr. Hudson's plea, he shot up in Walmart. He ordered him drug testing. He tested for almost the same thing he did today, and then left the courthouse after being told by Mr. Major to come back to the courtroom, and by the judge to come back in and prove the drug testing. There may have been some disconnect between communications between Riverside and Mr. Helton, that he was supposed to come back in here after he was drug tested. The judge had not taken his plea, which is his usual policy now before he sentences somebody on the shoplifting from Walmart charge, is he has been drug tested before he would accept the plea. Is that not?
I believe so. Yes.
All right, let's see if we can get a plea today then.
He's already pled.
No, wait a minute, okay? Are you telling me that he has not entered a plea or he has?
He has not.
All right.
Well, here, the reason that he was asked to do a drug screen is because that's part of the judge's procedure upon sentencing. he wants to have the drug screen before he goes through with the sentencing. So that,
Yes, Your Honor, that's what I'm saying. He did enter the plea of guilty. And the judge's policy is that he has a drug screen before he sentences. So that he'll know more about the case and what the sentence needs to be.
What do you have, Mrs.
I
Bledsoe?
know nothing about this case, Your Honor. I can speak nothing on the record.
Well, that has to do with continuous matter of sentencing, like when we discussed the side and releasing on whatever conditions Mr. Hill in court and that's what it is.
Well, you know what? Let's find out what the plea was, if he entered a plea. Then we'll talk about it. Let's see what, that's a good idea. What are you recommending?
That's what me and Mr. Major were just discussing. I've already got him set up with an outpatient assessment. However, if Judge Capper's wanting him to go inpatient, I can justify inpatient also.
Okay, let's take a recess and find out if he entered a plea. Okay.
yes.
State of Ohio recalls Brandon J. Atkins, case number CRP 23-138. Mr. Holt's case.
Brad's looking for it.
Is here, Brandon Atkins is here, Mr. Hield is here. Where are we on the time?
We are aware of the position the time has ran.
That's right.
Well, could be either.
I'm sorry.
I think both are grammatically correct.
That was in my mind and it came out, I'm sorry.
Mr. Hill and I believe would ask that it be set for a hearing on next Monday. I'm going to file a motion to dismiss based upon speedy trial, and we'll go from there.
We've also agreed that, I think Mr. Holt's already prepared an entry that, and I've agreed to it, that Mr. Atkins doesn't have to be here for the next hearing.
Thanks.
Well, why can't we do it on Friday?
I have a half-day hearing in Common Police Court on a parenting issue.
Which half?
The first.
Your Honor, you already signed an entry to that effect,
What did my entry say?
that the defendant did not have to be present at the hearing on Monday.
I signed this?
Yes, Your Honor. Just a few moments ago. I didn't have to file.
Well, I haven't filed this entry yet.
No, sir, you have not.
Okay.
I don't think there's a difference between it being Friday and Monday.
Well, my problem is Judge Capper doesn't want to add anything to Monday's docket. And I'm going to be here all day on Friday. But can you tell me that you'll be here at 1?
The only thing that might need also considered is that we are going to attempt to have the victim victims here to hear the motion so that they'll know what's going on, whenever that is. So if we're gonna set it for, like 1 o'clock on Friday, or whatever, then we just wanna know exactly what the time's gonna be.
I'll have to move stuff. I've got appointments set in the afternoon. I'm going to be here already on Monday, and I've got 3 cases already. I don't think this is going to be anything that's very time consuming.
Shouldn't be a real lengthy hearing.
So,
We can even set it for after that. The motion tolls the time anyway, if I do have an argument left.
I'll be back here on the 16th.
you're saying the time has run as of today?
Correct. But I have to file a motion. I believe Mr. Hill's requesting I file a written motion.
I think that he's saying that the time ran a long time ago, and I need to go back through the record so I can try to dispute that. But if he files this motion, it tolls the time also. So if the time hasn't,
With the motion, when I file a speedy trial motion, it tolls time, yes. I agree with that. But I think the record's very clear that time has run. Or ran.
Well,
has run.
I'd rather not, if the case is going to be dismissed due to speedy trial, then I don't want him to have to worry about that for 16 more days.
I think that we're on the same page. He and I have covered that. I think a big part of this was so that the alleged victims could come. That's what we were trying to accomplish.
You're going to be here on Monday, right?
Correct. I will be here. I've got 3 cases already set.
How long is this motion going to take?
I doubt we even have to put on evidence. The record's going to demonstrate that it's ran.
Right.
And I think that I would think less than 3 minutes. I don't
All right.
know.
June 5th,
Thank you, Your Honor.
based upon the word of counsel that it's going to take 3 minutes.
I knew you were going to.
I did put that on 11 o'clock for a motion.
11, okay, thank you.
6/2/23 at 11.
6:05.
6/5, that's what I meant.
I appreciate it. No problem.
See, I had
He's
it
running
for
down sometime this
6/2
week.
at
I gotta
11.
file a motion.
That's fine. I'm on out of town this weekend, so we'll be members.
Okay.
State of Ohio recalls Catherine Stapleton, case number CRB 23272.
I'll scan an email. She had to give me her training.
Perfect screen, Mr. Heald.
I'm glad to hear that, Your Honor.
So you're agreeing to the continuance,
Yes,
and that is until, what day did we say?
August 4th.
4th day of August, 2023 at 10 a.m. Thank you.
State of Ohio recalls James Helton, case number CRB 23111.
you can call. Well, but that's not if he wants to withdraw his plea, that's fine with me, but we're gonna want him to have a bond.
Who wants to start?
I'll let Mr. Hewitt go.
All right.
Well, Your Honor, honestly, we're not hung up on whether he entered a plea or not. I believe he did because that's the only way he would have been asked to go do a drug screen. He wouldn't have been asked to do a drug screen on a misdemeanor theft case before he was found guilty. That's the way the judge goes about his sentencing. However, if he wants to withdraw his plea, then we're going to ask for a cash or surety bond of $5,000, and we'll come back for a pretrial. So I would prefer that he follow through and get into the treatment, and that they admit that he pled guilty before or he pleads guilty now.
Well, your proposal will satisfy the issue of whether or not he pled. So if you're saying, let's just say that he did and you're withdrawing it, or I don't think that makes any difference. Either he, rather than have Dorothy try to figure it out, you weren't here, were you?
No, sir, I would have to listen to the audio, and that's not an exact science depending on.
Yeah, I've tried that myself.
It could take hours. I just have questions, and Mr. Sowers has to be released from the bond.
No.
I've been talking to him, he said he was still okay with it.
Now, your response to what?
If he ends the plea, we're going to add him to the plea, Judge Capler had issues up before him where
So what, is he going to enter a plea of guilty or withdraw his guilty plea?
he wants to continue so we can get his fair in.
Oh, wait. Answer the question, is he entering a plea today?
Are you going to plead it? Yes or no?
And I don't really have an answer. What I was asking for is just a week to, so I know, so my boss knows, so I don't lose my job and stuff, but I mean, I was okay with what was going to happen. I should come here. Sure that I could tell my boss and everything in case because after the assessment, if I get inpatient, I won't let my boss know, so maybe I won't get fired and lose my job.
Where do you work?
At Quality in my payroll and make it spend.
Where is that?
And ask them.
Can you all help him contact his?
Yes.
I mean, I'm sure they try to help him do as much as they can. He's got to be focused on getting into treatment. If he's
That's what I was
got,
asking, if I could come to court next week, because he got an assessment for Tuesday, and then I see Judge Capper, who originally started it anyways. And I showed up on my cases on my bond. I showed up freely today.
he had a dirty drug screen on the 26th on Friday and another one today, apparently.
Well, there's a little bit less today, but that's just from what was still in the system out of that.
We discussed on Friday the fact that he had been going to Mountain State treatment, but the judge said he wanted a different place because he didn't know about Mountain State treatment. And again, those are things that would not have taken place unless there was a guilty plea.
Well, I'm hoping to resolve the issue of the guilty plea. Is he entering a guilty plea?
Yeah, or not. It's not qualified to see,
Yeah, just trying to get continuous until next week, so Capper was here. Maybe we can just continue until that Capper is here.
Was there a bond posted previously?
Yeah.
Yes.
What was the bond for? How much?
I think $500 from Mr. Sowers.
$1,000.
We think that there needs to be a more significant bond, given that he left on Friday. What we're trying to do is keep him from doing further harm to himself.
So I would be willing to do the inpatient stuff. I was just wanting a week to handle my affairs. And I mean, I've been on bond and told times, Mr. Sowers, I've always showed up on Fridays, just a misunderstanding. So that's the reason I came today. I'm going to go through it.
You were called by your bondsman.
Yeah.
That's not your own free will.
Well, I already called my lawyer before that, actually. I told her I'm going to be here this morning.
I'm sure Mr. Wolford told you to show up. I mean, I don't know what you told him, but that's what I would have told him.
A court order is a court order is a court order. I like that from day one.
That's my main thing, is this is a great job, and if I look at it,
Okay, the question before the court is, are you going to have a guilty?
What's the gentleman's name from Riverside? How you spell his last name?
G-W-I-N-N.
Thanks. So, what's the plea, Mr. Morford? What is the plea? Guilty, not guilty, or not guilty?
Guilty.
Is that your plea, James?
yes.
Okay. Now, what's the recommendation for sentencing?
Well, if the counselors are ready, if they've assessed him and they want to go ahead and get him into a treatment, we want that to happen as soon as possible.
My assessment's Tuesday.
Come back to sentencing after a six assessment.
Well, I think that they can, about assessing him now. I think they're talking about assessing him now. We don't want him to wait until Tuesday.
Your Honor, after a little discussion, I think he needs to go to inpatient today.
Mr. Morford, your response?
I mean, if I'm taken from a job, I lose my home, like that, I don't see how anybody can think that that'd be the best for me. Like, I lose everything if I lose my job. Then even if I only did an inpatient, I come out from a job back in the streets, same as like, getting numerous times. Like, I feel like I should be given a chance for how I'm told to be clean, I will be clean. And if I did
How much time do you need?
just, I could be clean in a week, you know,
No,
whatever.
no. How much time do you need to talk to your employer and make sure that you have a job?
I have 2 more days left on this work week, I mean, so if I can finish out in 2 days, then I can be wait for one.
Before Friday.
How can we craft an entry? I want to give him the 2 days.
Well, based on what we know about the situation, he's endangering himself very badly. We're trying to keep a tragedy from happening. I understand he's got a job. I bet you if they knew the kind of drug use he's taken part in, he wouldn't have a job. And we want him to be able to live a healthy life and get through this treatment and then have really something to work for. And I understand he's got things he's going to lose, but he's going to lose a lot more.
My staff will be more than happy to help him contact his employer and make sure he keeps his employment. And we don't want him to die.
I mean, there's been nothing of drugs here, there's not been no drug problem. I mean, I thought a drug test, because I wasn't prepared for it, but I mean, I'm not running around doing drugs, I don't know why we use it.
Well, Mr. Morford, do you have anything else to say?
Craig, I'm shut up right now.
Do you have anything else to say, Mr. Morford?
No, Judge, I would just like until Friday for him to get over the court, begin serving jail sentence or inpatient treatment, whichever the assessment review.
Well, give me the complete recommendation, Mr. Hill.
Our recommendation would be a suspended jail sentence of 6 months with credit for the time he's been in there, and probation for 2 years, and go to treatment and follow their recommendations. Also, restitution to Walmart of $107.44.
Is that 170.44?
107.44. And that is what we would ask for, ankle monitor.
And you're asking for immediate entry into the program, correct?
Yes.
All right, Mr. Morford, your response?
We would concur.
You concur with everything he said except for the immediate?
Well, my client's concerned. I don't know what to do.
Well, yes, I agree with everything.
Well, you know what? I've heard everyone, I've heard all sides, and I'm going to err on the side of caution and go with what the state is asking for, based upon Bobby telling me that that your facility will do whatever it takes to help him keep his job. I don't think the 2 days are going to make a difference.
And I'm sorry, what is that treatment facility again?
Riverside Recovery Services.
Riverside Recovery Services. And I think that looking at the 2 screens, this entry will do the most to help James and help keep his job. I don't see what, at a certain point I was believing that the 2 days would be okay, and then I looked again at the screen and the amount of dangerous drugs that James is taking.
Review date.
All right, I need a review date. How many months are you asking for, Mr. Hill? 4 months or quicker?
The judge usually goes for sooner longer than your treatment.
When,
Did you send this to Tom?
how many days? 14?
I mean, usually about a month.
7/3, July 3rd, 2023.
That would be July 4th, Your Honor.
No, I want, the date I've been given is
That's right.
July 3rd. Is that right?
Yes.
July 3rd, 2023, at 9 a.m. for review. Released to Riverside with an ankle monitor. Thank you. Thank you. I wish you well, James. Thank you all. Court's adjourned.
Good work, Butch.
You didn't hear that here.
I didn't hear that.
You need anything? You don't have to take that.
Bobby, I'll see you 1 o'clock Thursday?
Yes, sir.
We'll run up and pick you up. Okay.